that we need to cover is that Mark Crocker has resigned his position as executive director, effective immediately. Since the position of executive director is vacant, the board staff will function with the under the direction and assistance of the partner, or the assistant commissioner of Commerce and Insurance, and I'll be available as needed. Respectfully request a motion for the Department of Commerce and Insurance to solicit applications of qualified candidates for the next executive director of the Tennessee State Board of Accountancy. This will be done in consultation with the Tennessee Society and Commerce and Insurance, where the applicants would be screened. I would also request the authority to constitute a search committee of the state board to review and interview those applicants recommended in the first process. The search committee would then make a recommendation to the full board, which would have final approval of any recommendation. And of course, I would welcome any volunteers who would like to participate in the search committee process.
Make that motion, sir, as presented.
Second.
Okay. Further discussion?
Chairman, before we get into the discussion, if you could go ahead and just as a matter of course call roll so that we know the participants of the meeting.
Would you like to identify yourself and present?
Charlene Spiceland, present.
Gabe Roberts, present. Ray Watkins, present.
Don Royston, present.
Bill Bloff is present.
Henry House, present.
Jennifer Brundage, present.
Vic Alexander, present.
Jay Moon, present.
Steve Eldridge on the phone.
Yes, I'm present, Stephen Eldridge.
Okay. So our only member that's absent is Casey. So there's been a motion and a second. Is there discussion regarding that motion? Any comments from Brian or Michael or?
Brian McCormack, Assistant Commissioner of Commerce and Insurance. I'm here to answer any questions, but I don't have any further comment.
We'll do a roll call vote. Charlene?
Aye.
Aye.
Oh, I should identify my name first. Charlene Spiceland, aye.
Gabe Roberts, aye. Ray Watkins, aye.
Don Royston, aye.
Bill Bloff is aye.
Henry House, aye.
Jennifer Brundage, aye.
Vic Alexander, aye.
Jay Moon, aye.
Stephen Eldridge, aye.
Thank you. Proceed with the agenda. If I can find it. First item is to the approval of the minutes for October 17th. And Karen, do you want to explain why we need to approve these minutes?
Yes, sir. Though you all reviewed the minutes and approved them, no vote was taken for the approval.
A motion to approve the minutes of October 17th.
So moved. Second.
Second.
Questions? All those in favor of the motion signify by saying aye.
Aye.
Excuse me.
I'm sorry to interrupt. Because we have one member joining us by telephone, all the votes need to be by roll call.
Okay. Very good.
Charlene Spiceland, aye.
Gabe Roberts, aye. Ray Watkins, aye.
Don Royston, aye.
Bill Bloff is aye.
Henry House, aye.
Jennifer Brundage, aye.
Vic Alexander, aye.
Jay Moon, aye.
Aye.
Very good. Motion passes. The next item was to approve the minutes of January 16th. Several questions have been raised about some of the how some of the issues and decisions are documented in the minutes, and a desire to go back and listen to the tape. We already have some suggested revisions, and my proposal is that we defer approval of the minutes until members of the board have a chance to review the minutes and consult with Karen regarding that. So unless there is an objection, we'll defer the approval of those minutes. We have the executive director's report, which is self-explanatory, but would anybody like to discuss any of the issues that Mark has outlined in his report? If not, we move on to the NASBA report on board effectiveness. Jennifer?
I have nothing new to report, Mr. Chairman.
Okay. I'm not sure. The board committee reports are listed here. They're not in the same sequence as they were yesterday that the committees met. I would probably suggest we start out with licensing, because an issue brought up there ended up with law and rules. So, Stephen, do you want to go ahead and report on licensing committee report?
Sure. Our committee met yesterday. We had 3 items to discuss. Let's see. The first one was a request. It was some requests for firm name approvals. I think the first one was a request by a firm called Eaton and Hartung PLLC. They wished to change their name, operate under the name of Eaton Tax and Accounting Services. We reviewed their information and determined that the Eaton person that would be named after is not a CPA. As a result, the committee recommends that the board deny this request.
Motion.
So I guess, yeah, I'll make that as a motion.
Second.
Discussion. All those in favor of the motion signify. Well,
Roll call.
roll call.
Shirley Spiceland, aye.
Gabe Roberts, aye.
Ray Watkins, aye. Alan Royston, aye.
Bill Bloffus, aye.
Henry Hoss, aye.
Jennifer Brundage, aye.
Alexander, aye.
Moon, aye.
Stephen Eldridge, aye. All right. The next items we had were additional requests for firm names. The committee discussed this and felt both of these fell under the question of whether or not it was considered a fictitious name. And as a result of that, the board recommendation was to bring in full board discussion to review, I guess, how we want to handle our future requests, what our policy is for fictitious names. I think everyone has access to a white paper, so we wanted to open up full board discussion for that. We basically suspended any requests for a possible fictitious name until we decided what our policy is.
Mr. Chairman, I would suggest to the board that we give some consideration to having a policy that if the name does not include a current partner or a former partner or the initials of a partner or former partner, then it seems to me it would be highly likely that it would fall into this definition or this category of deception or misleading. Although I know we really need to take them one at a time and look at each individual one, but It seems like that any time a group decides to go with a name that deviates from the names of the partners or the initials of the partners or former partners, that we're running into a situation where we're having a lot of difficulty in trying to figure out exactly what it is they're trying to do with those names.
Okay.
Further comments on the subject? Yes. Go to the speaker. I'm sorry, what?
We're here to speak on the fictitious names. Our name, my name is John Neville, Compass East. Our firm has been presented to the board to determine whether the name Compass East to be ruled as misleading.
Speak up, please.
Our name Compass East has been presented to be ruled upon if it is a misleading fictitious name. So I'm here to explain our stance on why it isn't. The ACCA committee published a white paper which we made aware that this board was reviewing in their analysis of fictitious names. In the white paper, the committee agreed that just because a firm name does not include the names or initials of one or more present former partners, members, or shareholders does not necessarily make it fictitious. They go on to say that the goal is to ensure that a firm does not practice under a misleading name, and that many states explicitly permit the use of fictitious or artificial names as long as they are not false or misleading. And in fact, they conclude that current specific rules addressing fictitious names are unnecessary. In a section referring directly to misleading CPA firm names, they provide examples that are notable for this conversation. The first is the CPA firm name implies certain favorable results can be achieved or creates unjustified expectations. For example, Maximum Refunds LLC. Second one is the CPA firm name implies the provision of a service that is not provided by the firm, for example, Litigation Services LLP, for a firm practicing accounting. The CPA firm implies or exaggerates actual available resources, size, or geographical reach. With these in consideration, our business name Compass East is not misleading. The fact that the name is actually very ambiguous. It is not false. It does not mislead the public to assume it's anything in particular. If anything, the name invokes intrigue of what the company actually does or provides in services, which can then be explained through our marketing and branding. And the public, with one look at our website or business, the public can clearly determine that we are an accounting services firm, with EAST being an acronym for the Entrepreneurs Accounting Solutions Team. So in the eyes of the public, we don't believe that the Compass East is false or misleading, and we ask you to take these views and statements in consideration. So, thank you.
Mr. Chairman, for the record, can I state that in the previous meeting I had recused myself for any deliberations about the Compass East name for a pre-existing relationship. I do have comments generally about the topic. So I guess my request for the attorney is, since we now have brought Compass East into this general conversation, can I participate in this conversation, or do I need to recuse myself from participating at all?
You need to continue your recusal.
Even on the general topic? Okay. Further discussion? Yes, did you have something? Yep.
I'm Dan McCarthy with Compass East. I wanted to speak more broadly about the topic than directly about Compass East. I also read the white paper and wanted to express my opinion on it. I believe that there's several factors that we should consider that could have a lasting impact on Tennessee's ability to attract firms to the state. Recently, when discussing the mobility of firm names, this board's taken a stance that a uniform reciprocal approach between states would yield the best outcomes for all stakeholders. And I'd implore the board to take the same stance when considering these fictitious versus misleading names, which I think we really need to start defining fictitious versus misleading and have solid definitions as to what those are. in April 2009, the referenced white paper, the AICPA Professional Ethics Executive Committee and NASBA published that white paper. The impact of adopting rules that for misleading names that are stricter than recommended by that white paper could include the following ramifications. The first is that a change of name will be confusing to the public. So I would ask the board if an impact study has been conducted to determine the number of firms that would be affected by a change in rules. But changing the names will be confusing to the public because there are several firms that would fall under this guideline that have a potentially fictitious name. And when a company changes its name, it's usually done after much forethought, and there's a heavy marketing price tag to overcome that change. When this type of change is forced on that company, the impact will be much more severe. And in the eyes of the public, this could lead to firms disappearing overnight and new firm names popping up in their place. Another point would be that there's an impediment to competition with non-CPA firms that compete in similar spaces. There's CFO service companies, there's bookkeeping companies, and there's tax preparers that are not required to register as CPA firms. And CPA firms are now diversifying their service offerings into those spaces. There's a potential for an unlevel playing field between CPA firms and these other firms that have the ability to name themselves under state rules for fictitious names. And if the board adopts a more strict stance than the state laws, then for those services, it'll be harder to market to the public. Lack of marketability. There's been a trend in marketing and naming companies where you're moving away from just what you do or who you are to actually invoking a feeling within the public. And I think that's part of what we're dealing with here. And we're moving away from companies such as U.S. Steel Corporation or Hewlett Packard based on what the person's doing or who they were. And now business owners understand that their last name might not be the best name for their company. Also, there's a potential loss of revenue for the board where firms who may not be specifically required. I know it's been discussed with tax services and the H&R Block issue as to whether certain firms are required. There are firms that choose to hold themselves to the CPA standard and be governed by the board. If they don't fall under those restrictions, they may determine that it poses a greater risk, the marketability of the business, than the actual benefit derived from being labeled a CPA firm due to the other things that I've listed. And the final thought that I'd leave is the impact to the goodwill of current firms. A lot of these firms have spent a lot of money and time marketing and their PR efforts and website domains and everything. There's been a lot of money put into a certain firm name and thoughts. I know our firm name, there's 6 months were spent just coming up with the name of a firm and acquiring everything. And I'm sure others have similar or longer stories. So in summary, requiring CPA firms with fictitious names to change their firm name will lead to potentially more public confusion, impede competition, impair marketability, and potentially damage existing goodwill. And we'd like the board to consider these factors when evaluating their stance on fictitious names.
Thank you. Are there questions of the speaker?
Are you coming from another state?
Yes, we're an LLC in Delaware who operates as a foreign entity. We're in Tennessee and we're registered with the board.
What's the name of your company in Delaware?
Compass East Financial, LLC.
Say that one more time.
Compass East Financial, LLC.
You say you are in, you just a Delaware corporation or Delaware
LLC? Yes, sir.
But you are Tennessee residents in Tennessee. I mean, you just chose to yes. Domesticate or whatever and incorporate.
Yes, we formed in Delaware and then registered as foreign entity in Tennessee.
Are you a firm registered CPA? Are you a CPA firm registered in Delaware?
We don't operate in Delaware.
So you formed a company a corporation or LLC in Delaware, and then you decided to become a CPA organization?
Clear. We started our company in Nashville.
But what's the purpose of your company?
We provide accounting services, and we.
And what was the name of your company in Nashville?
Compass East. We are Compass East Financial LLC, registered in Delaware, but we operate out of Tennessee. So we are a foreign entity registered here as Compass East Financial LLC, and we have a DBA Compass East.
So you formed your company, but you didn't ever register your firm as a CPA firm.
We are in Delaware. No, we are a registered CPA firm in Tennessee. We were originally called the Borough Group, and the name was changed. So
okay,
yeah.
That you were leaving something off there.
Yeah.
Okay, so you were the Borough Group.
Yes.
And that was the registered firm, and then you decided to change your name to Compass East LLC and registered in Delaware. And now you want to change your name here.
Oh, okay. So to back up, when we originally began our entity, we were the Borough Group LLC, registered in Delaware, but operating in Tennessee as a foreign entity, since this is where we operate. All we did was change our name. So we changed our name with Delaware, and then subsequently notified Tennessee of the name change as well.
But you didn't change your.
And then we submitted it to the board. But so currently the board has us as the Borough Group because we are not yet approved as.
Change has not been approved.
Right. Okay. So all of the point that you were just making about a name change is actually what you're trying to do.
The Compass East DBA and name has been submitted to the board, and so we're in a limbo position waiting for this fictitious.
But you understand your argument was that having to change names, et cetera, would be difficult, but that's actually what you're doing.
We've been operating as this for about 2 years now. It only became an issue to us when it was brought up, when the complaint was brought up.
And my point was that a firm can choose to change their name, and we did that with forethought. And the Borough Group, there was a point of changing to Compass East for branding, marketability, all of those points. And it was something that was brought on by the ownership, not by an outside board, to change the name specifically for those purposes. And so I think when the business makes that decision, that's a lot different than potentially a regulatory body asking for a name change on a firm.
Did you notify the state board at the time of your name change?
We did not at the initial time. It came to our attention that we forgot to do so, and that is when a complaint was brought to us, and we made all our efforts to come in compliance. And Mr. Crocker is all made aware of that, and we came in compliance. And then the only residual issue was that our name Compass East was brought to the board for you guys to approve it as whether it was misleading.
So you changed your name, didn't notify the board, and then operated for 2 years, and then it was brought back to your attention because y'all didn't.
It wasn't
notify us. Is that right?
It was 1 year where it was not notified. It was under 1 year, and then we are now came in compliance after that complaint. We made all efforts in good faith to come in compliance after we were notified.
Just hadn't been approved yet.
Yes.
That's where we're at, yes.
So, remind me, has the board acted upon this application for having Compass?
I think we've deferred it.
Yeah,
Okay.
They've been here before.
Right.
I mean, we keep kicking the can down the road.
Right.
Are you both CPAs?
I'm a CPA. I'm the registered 51% owner.
In the name that you're wanting to change to, are the letters CPA in that name?
No, it is Compass. It's the legal entity name is Compass East Financial LLC, and we have requesting a DBA to be Compass East. East is an acronym for Entrepreneurs Accounting Solutions Team.
Will that an acronym be spelled out on your sign?
Yes,
signage?
yes, it's on our business card, and I can show that to everybody here. It's on our website. It's in basically every branding, marketing, collateral piece of our company.
I assume that marketing
it will
material.
spell it out.
Correct. It will spell it out.
I assume that marketing material will also show that you're certified public accountants.
Yes, on our website, we make one reference, I believe, in a marketing piece that we are a registered CPA firm.
What services specifically are you providing?
We are not providing ad test services, so we're providing SARS 8, which was 1921 services as well. So, bookkeeping, yeah, according to management financials. So.
I'm sorry, what was the service you're providing? You said you were not providing a test
We are
services?
not providing ad test services.
What are you providing?
We are providing services that fall under SARS 8, which was then amended SARS 19 and 21 most recently. Some services fall into that with preparation of financial statements.
And that's not a test services?
That is defined as a test service in the state of Tennessee, am I right?
The SARS 19 was the financial statements that are prepared for management restricted use only, and that is not an ad test service.
Because it's not a compilation.
Okay.
It's internal use only or management use only.
Right. Correct. So our services are monthly bookkeeping services, CFO services for internal management. We're not providing ad test services or documents to third parties. If that helps clarify.
As has been pointed out, this has come before the board before, and we have not acted upon it. Is there a motion to approve their requested name change?
Can I make a comment before that, please, Bill? I guess obviously it's the board's decision, but our recommendation, I guess, from committee was that we suspend all name approvals until we can decide on a policy, rather than have to piecemeal things, because our concern was if we implement a policy then that contradicts previous decision we've made, then we didn't want to go down that road if possible. So I didn't know if we wanted to discuss in general how we want to handle these requests before we approve any names.
Henry, was your request earlier you were speaking, was that to provide guidelines for staff to then bring to the board? You had suggested that if it doesn't include initials, names, that it automatically be before this board to do an individual case-by-case approval, or where were you heading?
It seemed like that our policy ought to go in that direction.
Okay.
I'm not sure exactly how much further, but it seemed like that anything beyond the partners' names or initials or former partners, we get off into this gray area of being misled, and I'm not sure exactly how far. I'm not sure exactly how far you can go, but if that provides any guidance to the staff in coming up with a policy, then sure, that's exactly what I'd like.
That's just a guideline for us to approve on a case-by-case basis.
Right.
Because there's no way to define these fictitious names.
I think you're right.
If I could say one thing, in that white paper that the AICPA published, they clearly said that it would not be misleading if a name was not.
We get that, but all we're trying to do is provide staff some guidance as to when that needs to come before this board on a case-by-case. We're not saying we would not approve a fictitious name. What we're saying is they need some guidance as to when it needs to come before this board.
I think I'm curious just about another question. If they're not providing attest services, why are they registering as a CPA?
I mean, this goes to our whole point yesterday.
Yes, I mean, I don't understand what their value is in trying to register as a firm, but I do think that if that a CPA should understand the comment about why would a board have oversight on a name is. That's part of our duties. So, we do have the right to oversee the name, correct? I mean,
I'm not
his
sure we
comment
do.
that a board.
Well, if it's not part of the test services.
Right, I'm saying if it falls under our firm name, a reason to become an attest, if they want to register as a firm, then we do have the right to control the name. And so the point of, that an individual.
Question is do you want to register as a firm?
Yes,
and why?
And ma'am,
what would be the
I'm not,
value?
I'm not saying anything about the board's ability to rule on CPA firms.
We get that. We're just asking you, do you want?
I just wanted to clarify that my point was that if we're talking an open discussion about this fictitious names, that if the board adopted a stance stricter than what the AICPA and NASBA were recommending, that would force a lot of companies to change their names. I fully believe that if a firm is a CPA firm, that the board has every right to rule. So I just wanted to clarify that point. And I know you had another question.
No, my main point is after our conversations, y'all were here yesterday, I think, right?
Yes. Yeah. The
so
H&R blog.
We were informed that, essentially you don't have to register as a firm.
I am a CPA, practicing CPA, so as the current rule stood, and we understood it as you did before, in light of the general counsel yesterday, that if someone pulls themselves out as a CPA, they would have to be registered under a CPA firm, which is how we went about our business. And I mean,
now you learn that's not the case.
And now we have learned that's not.
So the question for y'all is do you want to be a registered firm?
We would like to continue being a registered firm, and that's part of the discussion. We would like to be in compliance with the board.
Well, why? What would be your value of being, if you're not going to do a test services, what is your value for being registered as a CPA firm?
Other than credibility, I guess.
But that's somewhat misleading, isn't it?
Well, if they're using accounting in their name, do they not have to register?
Not according to the attorney. As long as they do not provide a test services, they do not have to register as a firm.
It's very difficult, and to be honest, it's very difficult for us to answer that question before there's a determination of.
Which is what we're trying to do.
Yeah,
so that's one reason why we might want to put off your request. We need to understand better what's. Well,
I believe I understand that you put off our request for the name change, but at the same time, I think Mr. Haas had said that bringing those individual cases, if this is an individual case, it would be appropriate for us to at least get an answer, because we have to suspend marketing purposes basically if we're waiting for a determination of if we need to be registered and then if our name is changed. So
let's hear from the attorney real quick, because I think he had something to say.
And I was just for the discussion. I did not really want to get into the issue regarding the name, the fictitious name Compass East, but I did hear some discussion of some items that I'd like to point out. Is that under the statute, the statute requires that a firm must hold a generic firm must hold a permit issued by this board if they're going to do one of two things. If they provide a test services, they must be registered as a firm, and then it says or use the title CPA, which would indicate that
firm's not using CPA.
That's the problem.
Well, he said it was on the website.
No, he said he's a CPA.
But you said it was on your website.
Not in the firm name, not at all.
There's a potential reference on the website, which could always just be removed. But honestly,
it's not part of the name. That's what we're saying, is that if it's not part of the name and they're not providing a test services, I think we're pretty clear on that now. I mean, I don't think.
On his point, would you expand just a little bit about what you're saying? Was your reference to using the CPA within the firm, as when you hit there, Compass East LLC or P or whatever, whichever, if you hit that and then they say, here are the principles, Mr. CPA, non-CPA, whatever, is that inclusive in your interpretation of that statute using the word CPA or just in the firm name?
The way that I read it, when it says, because it says title, it doesn't necessarily say name, but it could be synonymous, is that it's open for interpretation. But it looks like if they're going to use the title CPA firm, PAs, or PA firm, then they would be required to have a license, regardless as to whether or not they're actually providing a test services. The other thing that I point out in the statute is that the board is, it appears that under the statute, if somebody meets the qualification as a CPA firm, then the board is mandated by the statute to grant a license.
Say it again.
That the board is mandated to grant the license if they qualify for a license. It does not say that the board may grant the license. It says the board shall grant a license if you meet the qualifications of the license.
Let me ask you this. Do we want to get into the business of granting firm or whatever, licensing these firms if they're not required to? Because I feel like that's heading us down a road of ruin, because if we try to take action for something that has been done wrong, or I'm not referring to y'all, just make sure you understand that. But if something were to happen in this situation and we tried to enforce disciplinary action against the firm itself, we couldn't do that. So we wouldn't have the statute. We don't have the statute to grant. We can't force them to have the firm permit under what you've been telling us. So why would we want to get into the business of even granting the permit? But just for the simple fact that if something ever came up, we could not enforce any action against them on that.
I think the grant.
Do you follow my logic?
Well, I follow slightly, which is that what I'm saying is that if somebody qualifies for a CPA firm registration, I don't think the board has the discretion to not give it to them.
But is not having a proper name part of the qualification process?
Yeah.
I mean, well, regardless of the name, I just really wanted to kind of put the name aside.
But are we not setting ourselves up for failure in that point? I mean, that's my point.
Well, I think that I think it's very possible that someone could say, I would like to be registered as a CPA firm, and I meet all the qualifications, and at this point in time, I don't intend to provide a test services, though I qualify for a license. And if the board says no, then that applicant would have a statutory and common law right to go to the Chancery Court and issue a mandamus against the board members.
So they get all the benefits of being registered, but when things go the opposite direction, we have no authority.
Well, the authority. What would you want to have authority over? What action?
Well, a lot of times we can revoke their permit. We can. I mean, I guess we could still do that. But
yes, sir.
And then my other question would be: is if it's a non-attest firm, do we have to have a 5149 ownership?
No, no. That's is my question. Part of our issue.
And I'm thinking now, y'all could be true partners. I mean, that's.
There was obviously a lot of ambiguity, so we tried to.
I know why you did what you did, but I think this whole line of process has just turned our process on its heels.
So this whole argument we've been having about fictitious names, and his point about wanting to compete with the competition. Well, H&R Block's out there, and they're not saying they're CPAs. They're doing taxes. There are other companies. Your company doesn't want to do attest services, so your idea is that you want to have a name that competes with other companies doing similar type work, and they don't have CPAs in there. So we put you at a disadvantage if you're trying to register as a CPA firm. So I guess that's my question. Why even? We can still have our rules about a CPA, the use of the CPA and the name of the firm, and those that are doing a test, which is really where we want to keep it. This is a different service than this service that this company is trying to offer, and keep them from trying to have the disadvantage in competition because they don't want to have the old name. They want a new exciting name like Compass East. So to me, they should just not try to register as a CPA firm, and it's not necessary based on what you said.
My predicament is that you registering, while it gives you certain amounts of credibility, is great, but it gives us no oversight authority technically over you as a firm.
The credibility factor is more, we would be more along the lines that I am a CPA and I hold myself out as a CPA. And under the current rules, when we were registering, our firm required that we register as a firm because I hold myself out as a CPA performing any type of accounting services.
Quick question for our board attorney.
Test services.
Well, we have levied fines against firms, haven't we? And we would not have the ability to do that in this scenario.
They were registered?
If they registered, then they come back and tell us later, well, I had no requirement to register. You can't impose a fine against me.
Oh no, we could. No, absolutely. If they have once they have a license, they come under the purview of the board for general actions. If they're, I mean, all of your prohibited activities, if they do something that's misleading or whatnot, oftentimes, and I be honest with you, I haven't looked in depth into what your statutes are, but oftentimes, in general, your licensees, whether or not they're performing within their license structure, such as giving a test services or not, once they're licensed and they do things that are deceptive or misleading, they fall under the purview of the board.
So the firm could be held, you think if this thing went to court, that a judge, based on your interpretations yesterday, would say, you have the right to impose a $10,000 penalty against this firm?
Oh, yes. If we have a license. Yes.
But you can still hold yourself out as a CPA and not register the firm.
Right.
So that it goes back to you know, is this something you even want to do?
I think if we received clarity and knew what rules to follow, that is exactly what we're saying. Is we want to hold ourselves to the standard of a CPA firm, and if the board will allow that, we read through all of the laws and the board rules, and the situation that we're in currently is because of those potential ambiguities, and we're looking for. We would like to consider ourselves a CPA firm and be under the guidance of the board and follow the board's rules. If that determination is made that we can't be.
You mean assuming that you keep the same name, but if we chose not to rule in favor of your name, then you might choose just not to register as a firm.
If that option exists, it's something that we would consider as a business decision. Yes, certainly.
Does anybody have a problem with this name?
I don't have a problem with this name.
I
I
don't
think
either.
we've discussed this ad nauseum, quite frankly. And, you know, the risk they run if they don't register as a CPA firm is that they're going to have a different board, a different attorney, and a different interpretation later on.
That's right. And
they're going to get a black mark.
Well, you weren't here yesterday for that part of the meeting.
I understand that.
But what's going to happen and what I don't know if you know this or not, is that we've asked them to alter the legislation to be more specific. So I don't know how big of an issue that's going to be. I agree with you. Everything's subject to interpretation, but we're hoping to stem that problem going forward with the change in the rules and regulations. So I don't know if that alleviates that or not. But
yeah, and all that I'm saying, I've been on this board for 9 years, and I can tell you the interpretation's always been that if you hold yourself out as a CPA, you need to be with a registered CPA firm.
Right.
So I understand the interpretation has changed now, but unless there's some great degree of clarity, some other board and some other attorney may interpret it differently.
I agree.
And these gentlemen may put themselves at risk by failing to register.
Well, the thought process that I've understood is that we would grandfather those names that had already been granted in the system, or I thought that's where we were leaning, so that nobody would be harmed, to y'all's point, for having already done that. And y'all are in a different situation because your name had never been approved. But I look at like CBiz in Memphis. I mean,
right.
You know, there's one. I don't know what
there's plenty that are already out there.
Right.
And for comfortability, if our name is approved today as a CPA firm, then for our comfortability, we understand we don't have to. It's not up in the air what board we fall under, at least in this limbo time while you guys decide how to handle this in the future.
Let me ask you a question on this.
Several times.
We've had some discussions.
Go ahead.
Oh, I'm sorry. We've discussed this, and I guess I'm hearing maybe I'm misinterpreting or mishearing a technicality. You say if a firm holds itself out to be a CPA firm, then it has to register with the board. But if a company holds itself out just to be an accounting company, they don't have to?
As long as they're not providing a test services, the interpretation that we've been given is that it does not have to file for a firm permit.
Okay, so let me go back to the to the one we voted on already, this Eaton Tax and Accounting Services. They're not saying they're CPAs, they're just saying they're Eaton Tax and Accounting Services.
I don't know if they're providing any attest or if it's purely tax or something other than a test.
I don't know that. We don't have that information. At least I don't have the application.
Right. Doesn't it, I think it says doing business as Eaton Tax and Accounting Services.
Right. But this Compass East is called the Entrepreneurs Accounting Solutions Team. So, I mean, they're obviously providing accounting solutions. So, I mean, I guess my thing is if we're determining that Compass East does not have to register as a CPA firm, then, or if they decided to, they would be okay to do so. What would be the difference with Eaton Tax and Accounting Services?
It just depends on whether or not they provide those attest services or not.
Mr. Watkins, their application indicates that they do not offer a test.
Okay.
Which one? Eaton?
The one you're talking about.
Okay. I mean, we'll have to go back and probably change that decision.
Well, you need to notify them, I guess, but we'd have to notify them, I assume, that they're not required to be registered.
I guess my point is this. I do have an issue with a company coming in and calling themselves, just because they don't say we're a CPA, but they're still holding themselves out to be an accounting company. And I base that on the same, sort of, and I'm not an attorney, obviously, but we require, for example, employees of our firm, we can't call them accountants. We have to call them associates now because of interpretation of the rule. So, I mean, I want to make sure we're handling the term accountant or accounting in a proper light, not just say because you're not a CPA, you call yourself a CPA. Because then, I think based on, I think it was Charlene's comments she made, are we opening the door for firms to come in and compete directly with CPA firms? I'm not saying they're a CPA, but they're saying they're an accounting firm or accounting company, whatever we call them. They don't have to follow the same rules. They don't have to register, and then they can come up with flashy names or whatever, and they're not limited by what they do as far as are we creating unfair competition to our firm members?
I mean, I think that's a question for the attorneys, but I assume as long as they're not using CPAs and they're not doing the test work.
There's a prohibition. No, it says there is a statute that says no firm not holding a license. So a firm that's not licensed cannot use the words accountant, accounting, or any other language, including language of a report that implies a person or firm holds such a license or has special competence as an accountant or auditor without being licensed as a firm. So it doesn't say anything about whether or not they're performing a test services, but even if they're using those words, they have to be licensed as a firm.
That was another reason.
That's what I thought. You said
Give me that
CPA.
statutory reference.
That statutory reference is 621113, parenthetical H2.
Thank you.
You're welcome.
So based on what you just said, then this firm, Compass East, is called, E stands for Entrepreneurs Accounting Solutions Team. They have to be registered.
Yes, it would be a violation if the
acronym does in fact stand for accounting.
Actually, now that you bring it up, would they have the word accounting in it by the statute? They would have to be a firm.
That's my point.
I mean, is it though with just an A? Maybe it's a direction. I don't know. I'm asking.
No, earlier we said they didn't have to register if they didn't want to, but my point is, I always thought if you had accounting in your name, held yourself out to be some sort of accountant or accounting company, that you had to register.
I'm going to make a motion that we approve this name so that we can move this conversation forward.
Second.
Further discussion? Roll call vote. Charlene?
Arlene Spiceland, nay.
I'm recused. Gabe Roberts, recused.
Trey Watkins, yes.
Don Royston, no. Nay.
Bill Bloffish, yes.
Henry Hoss, no.
Jennifer Brundage, yes.
Vic Alexander, yes.
Gay Moon, yes.
Stephen Eldridge, yes.
Motion passes. Okay, now we go back to the
Thank you.
Maybe you don't need to come next month, or you're welcome. you
But we
come
can.
next
We still
month.
can, though, right?
Yes.
Okay.
Oh, please.
Yeah.
We are always.
Thank you very
always
much.
in need.
You get CP credit for this, so you know that's state specific.
Right. Now we get back to the committee's recommendations. Stephen?
Mr. Chairman, can I take just a moment? Just to clarify, the attorneys, now that this decision has been made, I no longer have to recuse myself from this conversation. Is that correct? Thank you.
Stephen, do you want to go back to your committee report?
Yeah, and I think where we are now is just the discussion of, do we need to make a formal policy as far as how we handle these fictitious names in general?
I kind of liked Henry's comments of at least giving a guideline as to when we have to approve them. I think we're going to have to deal with these one by one. I don't know how else to do it.
I would agree. I guess my thing is I'm confused now, because originally and I'm using Compass East just as an example, not picking on these guys at all because we've approved it, but I heard early in the conversation that because they don't hold themselves out to be a quote CPA firm, that they do not have to register. But now, after we've discussed it, we're determining that because they use accounting in their name, that they do have to, in fact, register.
They will have to register.
So we're confident that if they use the word accounting, CPA, all of that, then they have to be. What about tax?
Tax, I don't think matters.
Okay, so Joe's tax service doesn't have to, or whoever, I just made that up.
At least the way the law is written today.
That's right.
Okay.
That's what we're talking about, maybe trying to change.
Can I ask a quick question on this? And maybe this is for the attorneys, and maybe this is, and not to put you on the spot, but maybe for next meeting, if Joe's tax service wants to get a CPA license and they come to us asking and they meet the other requirements, are we, I'm sorry, a firm permit, are we then required to give it to them if they meet the requirements of the rules?
The statute says that if they meet the requirements, then the board shall issue the permit.
So then I guess the follow-up question would be, what type of, we got confirmation that we could hold them accountable and we could discipline them, but we would need to know what the parameters of that discipline are so we don't waste our investigators' time in the event that a non-attest, non-accounting word firm has a CPA firm permit, and then we feel like we need to do something to go after them because they're doing something that harms the public. So I think it'd be fair to request what the parameters of that type of discipline action could be.
This could be a huge cost to our group. I mean, their time is a lot of time goes into these investigations, and
well, and I think yes, we would generally bring back is that so long as they qualify for a license, you would be required to give one. However, the revocation, suspension, refusal statute, which is 62.1.111, provides a listing of items that if they were in violation of, that this board could revoke or suspend or refuse to renew a license for a period of no more than 5 years. So when we talk about, I talked earlier about that once they get a license, they're under the purview of the board. And these violations here don't say necessarily that they have to perform this violation while acting in the capacity of a CPA performing attest services. So there's such things like fraud or deceit in obtaining a license. That's kind of clear, obvious. Some other ones that I highlighted is dishonesty, fraud, or gross negligence in the performance of services as a licensee. So it doesn't really go into saying that has to be attest services. It just says services. So if the company, I don't know if they're still in here, if Compass East is out there doing something and they had a complaint by one of their clients that they're committing some kind of fraud or gross negligence for whatever they're doing, then because they hold a license with the board, the board could revoke their license based on that. Now, after they don't have a license anymore, they could probably continue to do what they were doing.
That's what I'm saying. There's not a lot of teeth to it.
Well, what happens is they lose that credibility that they wanted in the first place.
Right.
And it's possible that if some of those actions were being done by their CPA 51% owner, we have purview over his license also.
Right.
So in all intents and purposes, if you took him out of his licensure picture, you essentially could almost make that.
Can I ask one question about that? Should we have them sign some sort of voluntary statement when they apply for these licenses that they understand that they're not required to file but they are putting themselves voluntarily in that position. Is that something we want, or do? The question I'm asking is because I foresee this being a problem down the road.
Right.
Y'all are good attorneys. I've never met a bad attorney. I guess there are bad attorneys, but my point is that somebody's going to come back. I've seen this enough times and say they should have never had to file as a firm to begin with. Therefore, our claim in court is going to be that you have no right to levy penalty against the firm itself. I agree with you that the CPA we can do that with, but maybe it would strengthen our position if they voluntarily sign a statement with the application that states, I understand that we are not required to, but we choose to file voluntarily because they deem it in their best interest to do so. I don't know.
I don't think that would be a good defense for them in a court setting as to whether or not the board had authority over the license.
They cannot. Well, okay. Let me say this: have you've seen these attorneys argue before, and I can tell you that's going to be an issue, and we're going to waste a lot of people's time and a lot of energy and a lot of effort. I'm talking your office, the attorney general, whoever has to litigate this stuff. It's going to be, and I'm not so sure that's not going to stand.
I mean, my concern is that I'm confused, and I'm a decision maker involved in this, and I'm a little bit confused because yesterday we made the point that the nuance of us taking the decision we made last board meeting was not based on the fact that they were providing non-attest services, is because they were licensed by our board and its behavior, and we felt like we had the purview to govern that behavior. And so now you're telling us that as soon as we get a license, but we were told that wasn't sufficient grounds based on this case out of North Carolina, which I think probably rightfully scared us all a little bit. But now we're saying that once we license a firm, even if they don't provide attest services, we can go after their behavior. So I'm just a little bit, I don't really understand the line of where our authority is an overreach, or where it's appropriate. And that's my concern. So I think what Mr. Watkins has proposed is a great idea, that they voluntarily submit to all the governance and rules of this, and they waive any argument that they aren't under the purview of the board if they aren't required to be registered. I think that's a great idea.
I'll let you finish that. I have another question.
I was trying to finish the thought. Is that I guess I get a lot of experience with. So I just practice administrative law. That's all that I do. So my entire focus is on the administrative aspect of these things, and I provide legal guidance to all 23 boards and commissions, and all of them have different statutes and rules. And over the years, I've noticed that some of those statutes and rules say that if you want to get a license from our board, one of the requirements is that you certify that your principal business is going to be performing as a licensee. So if you're going to be, for example, a motor vehicle dealer, you have to certify that your business is actually going to be selling motor vehicles within the function, within the licensing function. Your statutes don't have this. You're not required to say is that in order to be a CPA firm, you must certify that you're actually going to be conducting attest work as a CPA firm. It doesn't require that. So that's one of the things that I looked at earlier. The second thing is that also many boards and statutes have in their revocation, civil penalty, disciplinary actions, it says that the board, some of them say the board may assert disciplinary action against the licensee so long as they're performing within the licensee's scope of work as a licensee. And some of them just say in general, if a licensee does X, Y, and Z. So oftentimes we've had licensees that do things that have nothing to do with their license. We have licensees that do nothing to do with their license, such as you may have a real estate agent who gets convicted of some kind of fraud on a business relationship that has nothing to do with real estate. We take their license away all the time. It has nothing to do with their license, and they may make that argument like, this has nothing to do with my license. It doesn't matter. It says that you individually, if you commit fraud in general, we can take your license away. Because one of the things when you look at with people's licenses, individuals, is their character, honesty, and whether or not they've conducted anything in violation of like a moral turpitude issue or whatnot. So that is our argument that we go forward with in these types of scenarios. Mr. Watkins, if I could really address your question
my whole point is it harmful for us to put a paragraph into the application? It can't hurt us, can it?
I think that paragraph would probably need to be some. I don't think it can necessarily hurt you, other than an unintended consequence that you wouldn't want to say to somebody like this. You're actually not required to have a license, and you say that on the minutes, and then 3 months from now they say, "Oh, we're actually going to perform a test services." Now you actually do have to have a license.
Well, but that statement could be all encompassing to state that as long as we are not doing a test services, then we voluntarily recognize that we should or should not register. I mean, the people that are signing are voluntarily registering anyway, so I don't see that being an issue.
I don't necessarily. I mean, I don't think that. I think if it was worded correctly, so that they're indicating that they understand that they only have to have a license in order to do certain things, and we could list the statutes for those things, and that they could say further that any actions that they would have outside of this, that they would authorize the board to take action against their license for. I guess you could probably put that in there, condition precedent to licensure,
right.
That you could do that, and it would probably stand.
And the only guy in that relationship that we really have purview over is the CPA.
Yes.
Right. So we're going to have a registered firm now, which affects the other guy. Sorry, I don't know their names, but there's no course of action against him.
Maybe you could,
if he's the one that commits the fraud or whatnot, unless they're actually a registered firm, right?
Yeah. If they're actually
you follow what I'm asking? I mean, right. He's the 49% owner. He's not the CPA.
You don't have authority over him individually, but you would have if he's conducting that activity with the firm. If he does something that is gross negligent or let's just say fraudulent,
right,
and it's done through the firm, then you can hold the firm liable for his actions, even though it may not even be a test services, and revoke the firm's license so that they would not have their.
That's where I get back to this whole argument of, well, what if they weren't required to be a registered firm
right,
to begin with?
They could go back out and do the similar type things. Now, it's not to say that, that at that point in time they would have a bad business culture and goodwill or whatnot.
Right.
I mean,
Mr. Chair, I'm sorry.
Could maybe y'all could, between this and the next board meeting or whenever appropriate time, do a little more analysis on this and maybe come up with some language that might be better than what's been tossed around here today, or even tell us if that's not advisable after you've done some more legal thought and analysis about this, and we can continue the discussion.
I agree. We've spent a lot of time on this. Sorry.
But I have a question. I want to go back to this tax issue because I don't want to leave it hanging out there. When it was mentioned, if you had somebody's name that said Brundage Tax Services, I defer to legal, and you can look at this later. Looking at the reference that Mr. Landorf gave us earlier, 62-1-113H2, if you keep reading, after it says if you're a firm that's using accounting or accountant in the title, or it says, or any other language, in parentheses saying, including the language of a report, that implies that a person or firm holds such a license or has special competence as an accountant or auditor. And then it goes on to say, provided that such subsection does not prohibit any officer. I guess what my question is, as a member of the public, if you put tax out there, I think of a tax accountant. I mean, I consider that to be a competency issue in the accounting. So I put that out there. I don't want us to say today, well, anybody can use the word tax in their name and they don't have to be registered. I think that needs to be maybe looked at.
It's not specific enough.
I think I would like a.
Yeah, I think that's kind of where the Dental Examiners Board got sideways in the state of North Carolina, where they started to look and say, well, it seems like if you do anything with teeth, aka, and in that case they were whitening teeth, they said, well, this has to be within the role of the dentist because we do everything with the mouth, and we actually do whitening as dentists. So that's where they sent out those letters, and the FTC said that they were conducting anti-competition. I mean, that's my fear.
Yeah, but
honestly.
I guess just on the naming, like if somebody did come in, I mean, it would be important for us to know if somebody comes in with, or if somebody's investigating and finds Brundage Tax Services, and should I have registered as a firm, and does that get caught here? I'm not asking for an answer today. I'm just saying, obviously, we need to have this explored further and have a better understanding.
Be an agreement that you're going to come back with some guidance. And Stephen, doesn't that address what the committee was concluded yesterday too?
Yes.
One thing, Mr. Chairman.
Sure.
I think part of this board's concern is also centered around the fact that some tax services run ads promoting that they have CPAs. And so they may not be using CPA in their name, but that sure seems a lot like a kissing cousin to holding myself out as a CPA. And I would be very interested in legal's interpretation of our current law as to what our position should be in that case.
I'm happy to do that, Mr. Alexander, in conjunction with Chief Counsel Glandorf and the General Counsel for obviously this was an issue that, because that gets back to the commercials and the things that were running back at the last meeting that got the board's attention, and it's obviously going to be an ongoing situation, but I agree that this is taking too much of your time, and we need to fix whatever is wrong with both the rule that was mentioned yesterday defining accounting services, which, as you all know, includes tax, and how that intersects with properly or improperly with the statutes. And I'm happy to do that.
Before we proceed with the rest of the licensing committee agenda, I suggest that we take a 10-minute break. Stephen, you've got a couple more things to cover on your agenda.
Okay. We've got two more name requests for firm name approval. The first one is by a company called Dominus. They're asking to be called Dominus CPA Services or Dominus CPA and Tax Services. I think when this firm applied, the staff questioned whether or not Dominus was a fictitious name. I believe Dominus means, I'm just reading the notes I have, Dominus means master, and that could be an implication that you're holding yourself out to be the master CPA firm.
Stephen, that's not a name of one of the owners or partners?
That is no. The name of the owner, I believe, is Alex Lorenz, Lorenz. That's who the email was from. So, yeah, Alex L. Lorenz is the owner.
Anything, Karen?
The firm holds a permit under ALL Dominus CPA Services, PLLC. ALL is the owner's initials, Alex Lapalm Lorenz. He wants to have the DBA Dominus CPA Services without using his initials in the DBA.
So we've already approved Al Dominus CPA Services.
Yes, sir.
Yeah, his initials. Dominus.
What is the recommendation of the committee?
The committee did not have a recommendation because we were waiting to have the discussion on fictitious names before we proceeded with this. I didn't know which way it was going to go.
So we're going to defer this one and the other one as well?
No, they want to just make a decision.
We're pushing it to the board for full discussion since we didn't have the guidelines as far as to make a recommendation yesterday.
Okay, but we're still going to develop the guidelines, but we could still act upon this in the meantime.
We can. That's
okay. Is there a motion to approve or disapprove this? In the absence of a motion, no action is taken.
All right. The second item is the request from Pinnacle. Let me get to this. Here we go. The request from Pinnacle CPA Professional Services PLLC. The request is from a practitioner named Ronald Gillet, CPA. This is coming to board discussion again because to determine whether or not Pinnacle CPA Professional Services is or is not a fictitious name.
If I could add, this is the name that Mr. Gillet originally had chosen for his firm, Pinnacle CPA Professional Services, PLLC. That name was not allowed by the board at a prior meeting. He since became registered under his own name, Ron Gillet. So he holds a permit, but he would like the board to reconsider allowing him to use the original name.
Motion to grant that request?
I feel like we need to make some decisions on these. These guys have been hanging out there, and
I would agree on both of these.
Yeah. I mean, I think we're getting into this whole. Now we're getting these big adjective type words.
I just honestly, I don't see any difference between Pinnacle and Compass East. So we just approved Compass East, and my hesitancy is that I feel like we're kind of digging a hole. If we approve one, how do we not approve another? If we keep without some either we should stop and decide how we move forward, or there is no stopping. So that's my personal opinion.
Does Pinnacle not mean at the top? I mean, it's not implying that they're the top, they're the pinnacle, they're the highest, greatest CPA professional
There's
service.
a very successful bank in Nashville that certainly uses the name well.
Because they believe they're at the top? Is that, if we're saying Pinnacle insinuates that something's, which we could also use that argument Dominus or whatever, that they're both saying that those are high, and there is a definition that says you cannot set yourself out as being the best. So if we use that argument to deny these two, that makes sense versus Compass East. But again, I believe we need to be clear in why we are not voting for something per some description, some rule.
I'd like to just bring everybody back to this white paper that was put out by the AICPA and NASBA. On page 7, there's a paragraph in there called overreaching principle. And it says a CPA firm's name should allow the users of the firm's services and the public at large to recognize the firm's identity. In order to achieve this transparency, the CPA should not permit a practice under a firm name that would be misleading or could confuse the public. Seemed like the term Pinnacle would be confusing. Seemed like to me, in fact, both of these names, it seems to me that they would be confusing to the public of exactly what's being presented to them.
If it says Pinnacle CPA Professional Services and Dominus CPA Services, it sounds to me like they're in the business of public accounting, regardless of what the first name is.
I agree with that.
I
Even
thought
though that it's implying that they may be
the best.
The best.
Well, why would they put a name in it that would imply that they were the lowest?
Well, if someone came in and said, "I want to be called best CPA firm,"
Well,
what if your name was best?
Well, it says here,
it's not best.
It says if it implies certain other examples that may be considered to be misleading include the CPA firm name implies certain favorable results can be achieved or creates unjustified expectations. So
do either of these names imply
well,
that?
if it's Dominus meaning master or Pinnacle meaning top, then
you
that
would have to know what is it, Latin? Dominus?
Well, that's how they describe it. Right? They described it as meaning master in CPA
Master in CPA
services is how they describe it. And if they believe that they're describing master in CPA services, then it seems to me it falls under misleading because it implies favorable results could be achieved or unjustified expectations. And the example is maximum, so again.
But AAL Dominus was okay.
Because it had his initials.
It contained the initials.
Yeah.
Could. And if you have the right initials, BEST, then you could be BEST CPA services.
Keep in mind that that got approved before we got into all of this discussion a year ago.
Well, we're discussing this almost into
Every
oblivion.
meeting.
I mean, we haven't really made any progress in coming up with a rule that.
I guess the question is, though, how's the public going to be harmed by these names? And that's the underlying question.
Yeah, more importantly, I think there may be differences of opinion on the board, and so the best way to resolve it may be to just call the question.
Call the question. Is there a motion to approve Pinnacle CPA Services?
I'll make the motion to approve the two.
For the discussion, Charlene, start the.
Well, again, I'm hesitant if we just didn't do anything with Dominus, and now we're going to move forward with Pinnacle.
I'm going to ask that Dominus be brought back up.
Mr. Chairman, we're voting just on Pinnacle.
Just on Pinnacle.
Okay.
Restate that name that we're voting on. It's Pinnacle.
Pinnacle CPA Professional Services.
Thank you.
Is that correct?
That's correct. PLLC.
Ron Spiceland, aye.
Gabe Roberts, aye.
Trey Watkins, aye. Sorry.
Don Royston, nay.
Bill Bluff is aye.
Henry Hollis, no.
Jennifer Brundage, yes.
Nick Alexander, yes.
Gay Moon, yes.
Motion passes.
What?
Oh, pardon me, Stephen.
Stephen Eldridge, no.
Okay. Would anybody like to make a motion to approve Dominus CPA Services?
I'll do it since I did the last one.
Second.
Dustin? Roll call vote. Charlene?
Ron Spiceland, aye.
Gabe Roberts, aye.
Trey Watkins, aye.
Don Royston, nay.
Bill Bluff is aye.
Henry Hollis, no.
Jennifer Brundage, aye.
Nick Alexander, aye.
Gay Moon, aye.
Stephen Eldridge, no.
Oh, shoot. I'm sorry, Steve. Okay.
All right.
You're still at the floor. You've had the floor longer today than the meeting lasted yesterday.
I know. It's not my intention. All right, these last two items are pretty quick. The next item we discussed was there was a discussion of having an audit of state-specific ethics sponsors. Historically, the board approves a state-specific or an ethics provider, and they will provide their materials and they'll get the rules and they'll be approved. And that approval is indefinite. There's no expiration date. And there's no review process to make sure that they're maintaining the same standards of quality control and providing updates if rules change. So what we as a committee had recommended was that we implement an annual requirement for all providers to submit all their course information, all their attendance records, and all their evaluations on an annual basis to be reviewed by our staff. So the committee I would move that we do so.
Very good. Is there a second to that motion?
Second.
Further discussion?
Steve, would you mind did you include in there a copy of the outline of the course?
That's what all the course information, course materials, basically not just an outline, but also all everything they submit basically when they apply for a license, which would be I believe they send their full course materials, if I'm not mistaken. And then like I said, everything else showing that they are still compliant, which would be, for example, attendance records, evaluations, that sort of thing.
Motion's been made and seconded. Roll call, Charlene.
Charlene Spiceland, aye.
Gabe Roberts, aye.
Ray Watkins, aye.
Don Royston, aye.
Bill Bloffus, aye.
Henry Hoss, aye.
Jennifer Brundage, aye.
Alexander, aye.
Gay Moon, aye.
Stephen Eldridge, aye.
Mr. Chairman, I'd like to ask does that include the State Board of Accountancy when they have these classes across the state? Does that include the TSCPA and the classes they offer?
I think it's over. My understanding of it was the independent providers.
Just these ones we have.
Is that correct?
Yes, that's correct. Okay. All right. The next item that came up was the need to create an expiration date on these approvals. Again, historically, these have been approved, and it's just an unlimited approval. Our legal counsel let us know that this would have to go and be a rule change since we were changing the actual rules. The previous motion was not requiring a rule change because it's just enforced. It's just under review and enforcement of current policy. So long story short, just making a note that the Law and Rules Committee will be discussing this, and they may have already discussed it, setting an expiration date on an approval. Just to make a note. All right, the next item we had was a discussion of the TSCPA as a sole provider of state-specific ethics. Basically, we just got an update from TSCPA, Brad Floyd. The TSCPA is going to develop this fall a new online 24/7 low-cost or possibly free state-specific ethics course. Obviously, they're interested in being a sole provider. The committee discussed this, and we decided that we will review at the time that this course is completed, and then determine later if the sole source is the best route to go. But for now, just FYI that they are working on that and hope to have something this fall. I don't know if Brad's here, if he wants to say anything, but that was kind of the update from yesterday.
He has indicated to pass.
Thank you, Brad.
Okay. And that's all that I have. So
very
I'll
good.
Be quiet. Thank you.
Thank you, Stephen.
Thank you.
Law and Rules.
The Law and Rules Committee had two agenda items. First, we recommend that the board approve the revised policy statements. These are the Tennessee State Board Accountancy policy statements that we made some revisions to at the prior meeting, and then with one revision from yesterday's meeting, and we are recommending that these be approved for posting on our website. And I'll make that as a motion.
I will second that motion.
Further discussion? All those in favor of the motion signify by saying aye. Charlene?
Charlene Spiceland, aye.
Gabe Roberts, aye.
Ray Watkins, aye.
Don Royston, aye.
Bill Bloffus, aye.
Henry Hoss, aye.
Jennifer Brundage, aye.
Alexander, aye.
Gay Moon, aye.
Stephen Eldridge, aye.
The second recommendation was passed to us from the licensing committee to ask legal to provide documentation for an expiration date for the approval of those providers of the state-specific ethics courses. And I'll make that as a motion.
What expiration date?
I think what's going to happen, didn't we decide they were going to draw up the proposed changes and then bring
I'm sorry,
it back?
that's what I was asking, that we were recommending that the board
Do we have to have a motion
approve-
and a vote for that, for y'all to drop something for us to potentially approve?
Yeah.
You can just ask me to do that, and I'll present it to you at the next meeting, and that's when we would be taking the vote.
Okay, so that's our
Very good.
recommendation.
Very good.
We're asking.
Right.
And I will do it.
Thank
And
Anything else, Charlie?
that was all. I don't know. Do our other request about the rules being, does that need to come through our committee, or is that just a board? Okay. That's all.
Else we move on to enforcement.
Bob Rolston, I'm chairing the committee today and making recommendations for our temporary Floridian. Each one of you has in front of you on your iPad under the tab. So that I don't forget it in the interest of trying to adjourn today. Mr. Mills, would you first present the status of open complaints, please?
Thank you, Mr. Chairman. You have that on your iPad. Year to date by quarter, you can see that as of yesterday, we had 117 cases out, 77 of those in legal, and I think according to council, we're going to be looking at 49 today that will be removed after the disposition has been decided. Everything else is pretty straightforward. Got a nice graph there on the next page showing you what all this amounts to. I did tell the committee yesterday, I think perhaps next semester we'll try to get you some more information on historical data that Ms. Condon has prepared that we've been using in our ethics presentations. Might be a event. Well, I've got, Mr. Chairman.
Are there any questions for our status of open complaints? I believe you said we just had the discussion yesterday that a lot of the complaints that had been opened were as a result of the P10 matching and trying to clear that caseload. Is that?
Yes, sir. That's correct. We've had a little spike in the number of cases we've seen due to the P10.
Have you all finished all of that review of all the P10s? Or are you still working on it?
We've ceased to work on it at this point.
It was under direction of legal, right?
That's correct.
Thank you. You have the report of some 49 cases that we're going to try to handle here. They're divided into categories, and I'd like to have you, those of you that were not on the committee, the others had a chance yesterday and today to look over that report, or do we need some time to look over it?
Assume that everybody's reviewed it unless somebody objects.
There are no objections. Let's get started on it. We'll first handle cases 1 through 9 as a group. These are all under the recommendation from staff and council for recommended dismissals. If you just quickly look over them, see if there are any questions on any of those first 1 through 9. Questions? Hearing none, I would entertain the motion that we go with the recommendation of the committee and council and our administrative staff to dismiss the complaints. All right. I'm making the motion. Do I have a second to my motion?
I will second.
All right, I've got a second. All right.
Any discussion? All those in favor of the motion signify by saying aye.
Charlene Spiceland, aye.
Gabe Roberts, aye.
Trey Watkins, aye.
Don Royston, aye.
Bill Bluffus, aye.
Henry Hoss, aye.
Brundage, aye.
Alexander, aye.
Gay Moon, aye.
Stephen Eldridge, aye.
Thank you. Next, I'd like to handle 10 and 11 together. These are recommended cease and desist orders. And I have asked previously, after the discussion yesterday, our council to be sure that we don't have any changes in what we had yesterday, because our instruction came up a little bit later after our committee meeting. There are not any to be noted.
There are not, sir.
Thank you. 10 and 11, are there any questions? If not, I'd make the motion that for the committee that we accept the recommendation of staff and legal counsel.
Second.
Question. Roll call.
Charlene Spiceland, aye.
Gabe Roberts, aye.
Trey Watkins, aye.
Don Royston, aye.
Bill Bluffus, aye.
Henry Hoss, aye.
Jennifer Brundage, aye.
Alexander, aye.
Gay Moon, aye.
Stephen Eldridge, aye.
Could I ask the chairman? Could I ask a question here? On one of these these letters, if this was a multiple, if a second offense, a third offense, would we be made aware of that? If I noticed number 11 about a non-licensed company using the word accounting, if they're continuing to do that, even though we've issued a cease and desist letter,
If I may,
what action would be taken?
if they continue after the issuance of the cease and desist letter, then we would go ahead and open a complaint and take formal action against them. Yes, sir.
Okay, so I assume that this is the first time that both of these have been.
Yes, sir. They, for the most part, traditionally, we have given them an opportunity to stop the behavior before they move forward with a complaint and disciplinary action. And so if they don't, then when I bring the legal report to you, I would let you know that they were given an opportunity, they didn't take it, and that's why we're asking for some sort of disciplinary action.
The reality is that if they're non-licensee, our ability to enforce a disciplinary action is pretty.
As the statute requires that anyone using the title be properly licensed, it would then be a matter of taking action against unlicensed activity. We would have authority over the respondent because they are acting contrary to the Accountancy Act of 1998, and it would be a matter of bringing them before the board, going forward with a formal hearing, getting the AG's office involved. There are legal steps that we can take to make them stop the unlicensed activity.
Move on then to the next section, which would be items 12 through 27, where the recommendation is for a letter of warning. Are there any questions on any of those? Hearing none, I would make a motion on behalf of the committee that we accept the recommendation.
Second.
Roll call.
Charlene Spiceland, aye.
Gabe Roberts, aye.
Trey Watkins, aye.
Don Royston, aye.
Bill Bluffus, aye.
Henry Hoss, aye.
Jennifer Brundage, aye.
Alexander, aye.
Gay Moon, aye.
Stephen Eldridge, aye.
The next batch, 28 through 45. These are recommended consent orders. Are there any questions on any of these on the cases individually? Numbers 28 through 45. Hearing none, I'd make the motion that we approve the recommendations.
Second.
Discussion. Roll call. Charlene.
Darlene Spiceland, aye.
Gabe Roberts, aye.
Ray Watkins, aye.
Don Royston, aye.
Bill Waffus, aye.
Henry Hollis, aye.
Jennifer Brundage, aye.
Alexander, aye.
Gay Moon, aye.
Stephen Eldridge, aye.
And finally, cases number 46 through 49 are to move the cases to the litigation monitoring status. And if there's still litigation going on, and we really cannot act on the cases, but we'll monitor the progress as it unfolds. Any questions? Hearing none, I would make the motion on behalf of the committee to approve.
Second.
Darlene Spiceland, aye.
Gabe Roberts, aye.
Ray Watkins, aye.
Don Royston, aye.
Bill Waffus, aye.
Henry Hollis, aye.
Jennifer Brundage, aye.
Vic Alexander, aye.
Gay Moon, aye.
Stephen Eldridge, aye.
Also come from the Enforcement Committee. The Executive Committee met yesterday afternoon. We reviewed the financial results, which you have a copy of. There was really no unusual matters noted. That the new system that the state is implementing, our portion of the state board's portion of it, of the court system, is being charged to our surplus. And there's more to come with that, but not a major amount as represented yesterday. Some explanatory explanations of line item variances were provided. Are there any questions regarding operating results to date? As is traditionally the case, there's information provided by regarding travel. And that's self-explanatory. We had a considerable discussion regarding the complaints against non-registered professional services firms, and this is really the action that we discussed at the last meeting, and management proceeded to pursue licensees who were working for non-registered firms. It was done without consultation with legal counsel, who later got involved, and Tony made a presentation regarding the matter yesterday. Tony, do you want to address it for the benefit of the full board today?
I will. I think we had a very thorough conversation of it yesterday. Boy, and I'd hate to contradict what I said yesterday, because I felt like it was kind of all out of me at the end of it. But I apologize. But in general, after looking
That's
at
what you deal with when you're dealing with a bunch of accountants.
and
two lawyers.
and two lawyers, right?
Two
No,
lawyers.
but
Two good lawyers.
we yes, and what we had done is we looked at the facts and circumstances regarding the persons who had been sent letters, who appeared to be licensees, in general licensees who had been working at unregistered firms such as H&R Block, and reviewed their facts and circumstances under the statute and rules, and I could not find where the board would have the authority to require those individual persons to either register as sole proprietorships or to work for a registered firm when performing tax preparation services. And then we went through an analysis of the board's rules and regulations, and I believe that rule is, I just want to say it for the record, I think it's 02, I think it's 20-1-.11. I believe it's in that area regarding the renewals of, yeah, that's it, and that's regarding the renewals of and licensures of CPA firms, and it was subsection 1, and I indicated to the board that it's my interpretation that the correct reading of that of that section under the rule is regarding CPA and PA and or PA firms only, indicating that they are required when providing accounting services, no matter what legal entity, generally to obtain a license for each location in which they're operating. And I did not read that statute to require that any firm that's non-registered conducting tax preparation services would be required to be registered as a firm, nor did I read the rule to indicate that any CPA working at a non-registered firm doing tax preparation services would necessarily require the registration of a firm in order to do that. That was my comments in general.
Bottom line is that the action that was taken has been rescinded, and we are at the time being not pursuing this matter further. And I think, Gabe, you had some requests that the committee recommends that the staff and legal staff pursue.
Thank you, Mr. Chairman. Our goal yesterday we talked about was having absolute clarity in our rules, not only for us, but also for the public and the profession. And so we had 3 specific requests for legal counsel to do some review and get back to us for next meeting. The first was specifically look at the rule that Mr. Glandorf just cited, 0020-01-.11, subsection 1 and 2. And where it says in subsection 1, quote, each CPA and or PA firm, come up with an opportunity to clarify that means CPA firms and PA firms, which may be as simple as just adding the word firm after CPA before the and the or. Same comment for subsection 2 where it says CPA and PA firms. The second request was looking at the definition of accounting services in Rule 0020-01-0.01 subsection B, and review whether it's appropriate to include tax, consulting, and management advisory services in that definition, especially since that definition is used in the preceding rule we just talked about, and which was the basis of Mr. Glandorf's opinion yesterday. And then the third was a general request to do kind of, for lack of a better word, a dragnet through all the rest of our rules to make sure for 2 things. 1, that there's no other ambiguity regarding the above comments in this issue, and 2, generally making sure that there is no overreach of the regulatory authority that has been granted to us specifically by the General Assembly through statute, such that we don't get ourselves in a situation like this again.
This matter that was as referred to in the minutes of the last meeting that are being we've requested to review it to make sure that the minutes document what the consensus of the board at that time.
I requested a change on the minutes on a comment that I made that was not, I wanted better contextual because it skipped a lot of time in the discussion.
Any questions from legal regarding the request as outlined by Mr. Roberts?
On my behalf, no, sir.
Discussion of fictitious names. I think we have covered that. Unless there's anything that somebody else wants to add. Brad Floyd, on behalf of the TSCPA, spoke again regarding firm mobility, and it was agreed that they would, well, the recommendation would be that the Tennessee State Board communicate with all the powers that be in the various states to have mobility. Well, Brad, I'll let you phrase what your recommendation is.
Other state boards of accountancy who have not yet adopted the provisions in firm mobility to do so. Tennessee's one of 14 states, 36 of the 50 states, and I don't know which of the jurisdictions haven't, but it's our desire for this board to go on record and encourage states to. In the event that they don't or refuse to consider it, it may be appropriate for this board to offer reciprocity to those states that do offer it to Tennessee firms, and only offer it to those firms that will reciprocate on that issue because it's creating big problems for a lot of our really good firms and unnecessary paperwork and burden that we don't provide on individual mobility. Everybody adopted individual mobility, but only 14 states thus far have seen the wisdom to adopt firm mobility. I understand it's being pursued in some states. I understand that some states have dug in and don't want to consider it, but it's incumbent, I think, upon us as a state to reciprocate on the issue and treat a state's firm like another state's firm like they treat ours.
You're gonna draft
right. We can
proposal.
draft you a letter for consideration, and we'll also supply some background information on the issue that you may want to use to consider when you're drafting that letter.
Very good. Thanks, Brad. That concluded the items covered by the executive committee yesterday. On the agenda, legislative review, Kim.
Will be short and to the point. There were no items of note that affected the accountancy board in the legislative session this year. So,
on the agenda is sunset audit status. We had invited the auditors to come and give us a status report. They declined because they didn't want to they weren't in a position to give an interim report. But I think they have contacted probably some of you on the board, contacted the society. They've met with the executive director at length. It appears to be a comprehensive audit that, as best as I know, it seems to be progressing as planned with no unusual problems. Focusing in on such issues as mobility, they're really getting into some of the issues that we've been struggling with as well. So hopefully. Under new business, I would point out that several terms are coming up for expiration or board members' expiration or renewal, and that will take place with work between the society, working with submitting names to the governor's office for consideration by the governor. And then typically we have waited until the board has been reconstituted for the election of officers, and hopefully that will be done at the July meeting. So give some thought as to who the board would like to have as officers for the next fiscal year.
Who is up, just out of curiosity? Is anybody up this term? Yeah. Y'all. You're not limited, are you? Are you limited?
No.
What term is this for you?
No, I'm not. I'm a holdover for a while.
Okay.
She is the only person that has gone for a 6-year term.
No, I filled an unexpired term, my first one, and then I was reappointed.
And around unappointed or.
I've been filling out the statutory section says you shall serve until your term is filled.
Very good.
Thank you.
The role of the attorneys on this board continues to be appreciated. One of the things at the beginning of the meeting that I failed to do was make sure that, for the record, that the meeting had been duly called and posted on the website. I don't have the exact date, but it was done. Or Karen, do you have it? Or it was done in the appropriate timetable?
Yes, sir.
Okay. I would just remind the board that solicit your input and help as we proceed with the search process for a replacement executive director, and we will keep you posted as to how we work on that with the society input and from the Department of Commerce and Insurance. But if you have would like to participate in this process, please let me know. And if you have candidates that you think should be seriously considered in that would be outstanding for you to get the information. But we'll get the information. This is the information out to you as to how that process will proceed in a more specific fashion.
Chairman, is it the candidates have to be a licensee, have to be a CPA? Is that correct?
Yes.
Okay.
Right.
And Mr. Chairman, how would we, if we had a recommendation for someone, a potential interview candidate, who would we send that to? Okay, gotcha.
Work in progress.
Gotcha.
Right. Activate your license. Are there any other matters to come before the board? Appreciate everybody's participation and have a safe trip home. We're adjourned. I do it for the pay.